Hi, all. I'm Daniel Tipton, one of the grief services coordinators at Four Seasons Hospice, and I want to welcome you to our first ever grief services vlog. The goal of this video is to connect our grief services experts with other experts and community partners around Western North Carolina to help us educate our grieving community on topics related to death and loss. Today, we are going to explore one of the most shared concerns we hear in grief services, in the early days after the death of someone that our patients or families love. That question or comment is, this estate probate stuff is just so overwhelming. I had no idea it would be this hard. One of the most common experiences in the early days of loss is what we in grief services call grief brain or grief fog, brain fog. This experience is natural, it's normal, and it's a very common reaction to loss. However, it can create a feeling or a sense of unreality. It can slow down our thinking, and sometimes it decreases our feelings of confidence in those early days of decision making. Unfortunately, this is the way life works. And typically, most of us seem to have these big financial and legal demands, like setting up a probate, beginning an estate, filling out paperwork, filing deadlines that demand we be intentional and clear minded. It's one of the hardest things we typically do. And now we have to do it while grieving. So today, I have invited a friend of Four Seasons to help us begin thinking about smart and intentional ways to navigate the estate process. Allow me now to introduce you to a great friend of Four Seasons, Koral Alman,
Yep.
is principal with the Van Winkel Law Firm, specializing in estate planning as well as trust and estate or probate administrations. And Coral works closely with clients to determine the specific goals and helps them develop customized plans to meet their unique needs. Coral is no stranger to Four Seasons and has served on the Four Seasons Hospice Board of Directors since 2021 and is currently serving as the Four Seasons Hospice Foundation Board Chair. Coral has seen firsthand the impact that Four Seasons does within this community in Western North Carolina, and I think she's proud to contribute as she is able to the organization's important work. And we definitely benefit from her expertise and her generosity in the work that we do in this area to bring not only high quality end of life care to Western North Carolina, but to help us provide this very high quality and intentional aftercare grief services program to anyone in Western North Carolina who has experienced the death of someone they love. And because of her work and the work of others in our community to help support our foundation, we are able to provide this service to anyone who needs it at no cost to them. And so I had to just use your expertise today, Coral, because like many of our clients who tell me first up, the first phone call I make after the death of someone they love, I have no idea what I'm doing either, right?
Yeah.
I don't know anything about law. I
Yep.
don't know anything about probate. And I especially don't know anything about how to even start the process. So
Yeah.
welcome. And I look
Thank you.
forward to hearing all your wisdom and hopefully gaining some thoughts.
Good. I hope I impart it well. So,
Oh yeah, I know you will. Just a little caveat for everyone to know: even though Coral is an attorney,
mhm.
this is not to be construed, I hope, as legal advice, but just sort of education about where to start the process, and that if you need legal advice, seek out someone who can do that on a legal way, right?
Yeah.
In the
Yeah.
proper
Yeah.
ways, right?
This
You may
doesn't
explain that
create
better.
an attorney client relationship
Yes,
between me and whoever is watching. So, if you have questions about your unique situation, make sure you talk to an attorney in your area. Yeah.
absolutely. Thank you. Thank you for
Yeah.
clarifying that.
No,
So
you're great.
Coral, how do we start this process anyway? Like
Yeah.
someone that you love has just died, someone you care about deeply, you're
Yeah.
in the throes of the early parts of grief. You don't
hmm
even know how to think straight right now.
Right.
You know, you may have a few days in between death and the funeral and after that to sort of get yourself a little together, but where do we start? How do we even
Yeah.
start this process?
So the first thing to remember is that there is no immediate rush to reach out to your estate administration or probate attorney. There is no immediate need to handle things. People often panic a lot about I'm going to lose access to the money. I need to pay these bills. These people are calling. Every creditor that I've ever interacted with in my practice understands that there is a delay in time between someone's death and when their loved ones have access to the money. Okay, so the first thing is there's no rush, in part because we can't do anything until we have a death certificate, and we won't get a death certificate usually for almost 2 weeks. Sometimes you get them shorter, sometimes it takes longer, but we can't do anything until you have that. So take the time to grieve. And that's a process, and it's not going to be done by the time you meet with the probate attorney, but at least then you're, there's just nothing is harder than someone coming the day after they've lost a loved one. What do I need to do? You
Right.
need to take a minute and sit in what you're in, because the reality is I can't do anything anyways.
Absolutely.
So that's step one. Okay, but let's say we finally have the death certificate. Now, look, I don't want y'all waiting a year, 2 years before you contact someone. A month or two when you're feeling ready and able to do this a little bit. You need to meet with your attorney. You can also meet with the clerk of court. This is all relevant to North Carolina law, by the way. And you're going to determine whether or not you even need a probate or estate administration. This is going to be my plug early on. Everyone needs estate planning documents. I don't care that all you have is mama's house and everything's going to go to my kids, or you've got this small. Everyone needs an estate plan, because if you don't make it for yourself, the state of North Carolina has made it for you. And they do so based upon what they think would be fair in most situations. And almost never is it what someone actually wants. So you would be meeting with your estate planning attorney or estate administration attorney and discussing, what did mama own? What did daddy own? What do we need to deal with? Because the answers as to what sort of situation you're in are very dependent upon what was owned at the decedent's death. Did they own real estate? Where was that real estate? Did they own a car? How was the car titled? Do they own a bank account? Was that jointly owned with their surviving spouse? Are there beneficiary designations? These answers are different for literally everyone, because everyone owns something different and has it titled or structured differently. So that's the short version.
Okay. Well, no, that's great. That's great. And thank you for emphasizing that it's okay to breathe, right?
Yeah.
That we don't have to do all of this the day after someone dies.
I will tell you, there are basically two general types of clients that I see come in. There are the folks who have not taken the time to breathe, and they're like, I'm going to get this done tomorrow. That's not true. It's going to take some time, and we can talk about that. Those folks do grieve. They just grieve later in the process, usually when I have a court deadline. Okay. The flip side are the people who take the time and come when they're ready, and are still, of course, in processing this, but are better able to handle it. And then I guess the third category are the people who ignore the problem because of their grief, and then we have a different issue.
Absolutely.
So,
Yeah. Just totally ignoring the whole thing
yes.
until it's a crime. Until it is a crime. Right.
Right.
Yeah.
Being an ostrich never solves any problem. So,
Right. Absolutely. Yeah. Yeah. So that really helps me answer the second question I was going to ask, which is, how long after the death of my loved one
mhm.
should I begin the process? And
Yeah.
so what I'm hearing you sort of suggesting now is that it doesn't have to be the day after. It can be a few weeks. You need certain documents.
Right.
What's the general consensus in what you would say, advise someone to say? 2 weeks, 3 weeks, a month?
So you can always reach out to your attorney to get on their calendar. But what I always say is, like, there's not necessarily a need for us to have a call or meeting that week, in part because, again, you're not going to get those death certificates for 10 to 12 business days. Okay. I'm perfectly fine for you to call that day if that's what makes you feel better. And we'll set up an appointment maybe in 2 weeks. That allows you also time to gather bank statements and whatever financial information you're able to collect. I would say you're welcome to call as quickly as you want, but anything within the first 3 months is probably ideal. On the earlier end is fine. That being said, take the time. I've had people call me Sundays at 2 a.m. and it's like,
Yeah.
go home.
Right.
Okay.
Right.
Yeah.
Yeah. There's a hard balance between, the things that have to get done and the things that can wait if they should. And I think a lot of people early in their grieving find it very difficult to know how to prioritize those things.
Yep.
And so what I'm hearing you sort of suggest is prioritize getting the death certificates,
Mm-hmm.
gathering as many documents as you can,
Mm-hmm.
but don't hurt yourself, right?
We've got time. Yes.
We got a little time to get some things done.
When you meet with the attorney, they're going to help you prioritize, right? They're going to help tell you, we don't need to worry about that one. That one takes care of itself. Now, this one, I need you to do X, Y, and Z. And generally speaking, I have homework that I send people home with. Okay.
Yeah.
You've got me in 80% and I still need whatever.
Yeah. I like homework. It gives me I like a checklist, right?
Yeah.
And so,
Yeah. It's a
um,
good way to focus your brain when you're in
absolutely.
grieving.
When things
Yeah.
are so chaotic and big anyway,
Yeah.
yeah. So that's good. Thank you for affirming that. I think that's a big help that a lot of folks just assume that these things are legal things, like you mentioned earlier. I have to get paid. I have to,
Hmm.
how the bill's going to get paid. How am I going to,
Right.
survive? Oh, good. Okay. So a lot of folks tell me early on that they feel alone in this.
Hmm.
And part of it may be just because it's a legal issue and legal code is hard to understand. Legal language, law language is difficult for a layperson to sort of muddle through.
Hmm.
Is this something you would advise someone doing on their own? Is it smart to have a counsel in this?
Yeah. Um, so it very much depends. Some people are well suited to do it on their own. It also really depends on what the assets are and what the plan is. You can do it alone. Either the probate process, which is overseen by the clerk of court in the county in which the person resided, and the clerk's office can help to some degree. They can tell you what forms. They cannot give you legal advice. They can kind of help you fill out the forms, but not really. So if you're able to figure it out, you absolutely can do it alone. That being said, I can't tell you how many clients come to me because they are convinced that they can do it by themselves and they start it. And then they get to a stage where they're like, ooh, I actually don't understand this at all. And oftentimes by that point, they've made some mistakes in the process that we now have to clean up. So the concern is often, well, I don't want to pay an attorney to do this. I can do it myself. And in many situations, it ends up costing more because we're cleaning up a mess. That might be a good segue also to sort of like the broad strokes of what the probate process looks
Mhm.
like.
Yeah.
So let's imagine we have assets that require us to open an estate administration in the county that the person died. If you have a will, you would be following the terms of what the will says as to who receives what and who is appointed as executor. If you do not have a will, there is a state statute that indicates who has priority to serve as your personal representative and who receives what assets. You would be filing documents with the court. We sort of collectively call the packet of documents that get filed qualification documents. And the point of those documents is to identify who is going to serve as the administrator of the estate, who is the person tasked with doing the work, who is the decedent, who are the beneficiaries or the heirs, and then you're filing copies of the will and death certificate with the court. The court evaluates and determines, yes, you are eligible to serve, you are over 18, you are not a felon, etc. They will then issue a document that's either letters testamentary, that's if you have a will, or letters of administration if there is no will. Now you have a piece of paper that allows that individual to act on behalf of assets or interests held by the deceased individual, either in their individual name or in the name of the estate. And then we will be running a notice to creditor. That's to basically ascertain whether there are any debts owed by the decedent that we need to address from our assets. And we begin working on an inventory that is filed with the court. The inventory reports all assets owned in the decedent's individual name as of date of death to the penny. And this is sort of the joke I often make when I'm meeting with clients. Yes, to the penny, because part of this process involves then reporting to the court on an annual accounting what happened from date of death, every penny in and out of that account until it is fully distributed in accordance with the will or the state statute. And again, I mean penny. So this is sort of where folks often start to lose the thread. Okay, I can fill out the documents and get the estate open, but I've got to report the value of this stock as determined on date of death and any changes in that stock until it is distributed in terms of distributions or dividends or interest or things like that. Because the role of the court is really to make sure that your executor is not borrowing money that they're not supposed to be borrowing or paying for bills that are their bills and not the decedent's bills. And the court does that by very closely auditing those accountings and documents. And then we also have to deal with final personal income tax returns and all of that sort of stuff during that process, paying our debts, paying our taxes, making sure everything gets squared away, and then ultimately distributing to whoever our children, grandchildren, whoever, charities. Yeah,
Yeah. That's a lot of moving parts.
it is.
So not only do people who are grieving already have the brain fog and the sort of like just the heaviness of grief itself,
Mm-hmm.
but you have to understand legal language and follow directions there. You have to be an accountant and understand simple
Yes.
basic mathing skills
Yep.
and just be on the ball with a lot of stuff that's kind of
Yes.
like a lot of moving parts. So,
Yes.
yeah.
So my job is often to set a task list. Okay, you need to go to the bank and do X, Y, and Z. And then I'm preparing also the underlying documentation so that you're not having to do the accounting. There are some things that the executor has to do that I can't do, but that is sort of the broad strokes of the process.
Well, what if I didn't want to do a probate?
Hmm.
What if I wanted to avoid this altogether?
Hmm.
And so I've heard some people say, well, I was the co-owner of the account, like a bank account or
Right.
a trust or whatever. I don't really know all the language myself. Different types of accounts, stocks, whatever. There's these monies that I have and I was co-owner. Can I make my kids the co-owner of the account and just have them sort of take over after I die?
Yeah. So this is sort of the importance again of having your estate planning done before you pass. And there are options that we call sort of will alternatives to a last will and testament, including using beneficiary designations on bank or brokerage accounts. So at my death, my account goes a third, a third, a third among my 3 children. There are lots of ways to do that, but you need to be doing them with intentionality and not just an ad hoc, let's slap this together. And the one you touched on is the one that always gives me the most concern is adding a joint owner. Folks often do it for a couple of reasons. They say, I need my daughter to start helping pay the bills. I'm going to add her as a joint owner and she's going to help pay my bills. No, ma'am. That is when we are using a power of attorney to have someone help take care of your financial affairs. Or they say, well, I've got these 3 kids, but I'm going to make my daughter the co-owner and she'll just gift it to
Mm,
her brothers.
mm,
Okay.
mm.
I know she's good for it, so on and so forth. You're creating a couple of problems by doing that. One, by adding her as a joint owner in this example, if that child gets into a car accident and gets a judgment against them, your money is now available to pay her creditors, her judgments. And that's usually not what we want that money for. That is your money to get you across the finish line. And if there's some left over at the end, great. And if there's not, I don't want it going to pay for some insurance claim. So that's one. 2, the example of, oh, I'm going to avoid probate by just putting my daughter on this and she'll gift it to her siblings. 1, sometimes your kids aren't who you think they are, and they don't do it. 2, sometimes they have every intention of doing it at the time, but they have a falling out. Or 3, they do want to do it the right way, but you have potentially created a taxable gift situation for that child in giving the money to their siblings because it's over the gift tax exemption. And so if she were to give the third that goes to her brother, she might now have to file a gift tax return. And she wouldn't have to do that if it was part of the estate. So when you're using beneficiary designations, because we don't want to use the joint owners unless you're a married couple, we want to make sure that also your beneficiary designations line up with what your will says. If your will says a third, a third, a third, we're not naming one kid as the beneficiary. We're naming all 3, or we're not using a beneficiary at all, and we're going to let it pass through the probate estate because there are benefits to the probate estate process, least of which is that notice to creditor thing we're doing, right? When we're doing that, we're cutting off creditor claims. You've got 3 months to tell us if this person owed you money. And if you fail to meet that deadline, too bad, I'm so sad. I don't necessarily have to pay you. We have to address any creditor claims, but if they fail to timely file, that they might be out of luck.
So there are some benefits to the probate.
Yeah.
Even though it's sometimes confusing, sometimes a little time
Yeah.
consuming,
Right.
the benefits, could you outline some of the other benefits?
Yeah, the big one is really creditor ascertaining. The other is it ensures that there is a pool of assets to actually pay your debts and expenses from. I have many clients who come in and they say, I am debt free. I pay all my bills on time. And I bet you do until you're in maybe a very serious last illness. And now we have lots of medical debt because you were sick for the last 2 months and insurance hasn't finished processing. Okay. We want to make sure that there is a pot of money that is readily available for paying those creditor claims. If I name beneficiaries on my accounts or have a joint owner, that does not mean that those assets are not available to pay creditor claims. I don't get to pretend I don't have any money by putting a beneficiary designation on it. Rather, that money is still available to pay creditor claims if it's the only money that there is. But I might now have to claw that money back from 3 people who got it automatically by your beneficiary designation. And we're going to hope they all participate pro rata and that burden doesn't fall on the eldest child or whatever who always does right by mama. But the real big one really is ascertaining creditors. And also that's important for real estate and dealing with title issues for real estate.
So it sounds like it's a smart process. It's a smart thing to do this a lot of pre-planning before it
Mhm.
actually gets to the time when
Right.
you actually need this. So for those of you who are watching who have time, right? So for those of us who weren't quite at end of life, or we have time to set up some
Mhm.
pre-planning wills, trusts like that. What would you advise to do first, a will or a trust?
So everyone would have a will. Even if you have a trust, you generally would always have a will as well. And the reality also is we want to make sure that you're also being taken care of while you're still here and alive. This is an important concept. There are documents that are designed to take care of you while you are alive. A living will, healthcare power of attorney, durable power of attorney, and then we often also do a HIPAA authorization. Those documents allow someone to take care of you while you're alive, but they all go away when you die. Okay, you cannot use a power of attorney to handle assets of a deceased individual. And I'm going to say that again. You cannot use the power of attorney to handle the assets of a deceased individual. People do it all the time or try to do it all the time, but that's when your will kicks in. If you also have a trust, you would have a will anyways. Your will would handle any assets owned individually at your death, and generally would say, if you have a trust as well, it's a pour over will. Your will says, to the extent anything is owned in my individual name at my death, send it to my trust, and my trust handles who gets what, the actual distribution plan. Now, when people need a trust in addition to a will is I know people hate hearing it, lawyers say it, but it depends. It depends on your situation, on your family, on your distribution plan, on your assets, on your beneficiaries. If you've got a child who is just a spendthrift and is just terrible with money, and you need to keep it in a protective trust for them because they will blow it in a month, you might need a trust. If you have a really wackadoo plan, meaning there's just like tons of percentages, and if this person doesn't, well, we're doing that. We probably don't want to do that in a will because of that detailed accounting I talked to you about earlier. We probably want to trust. If you've got a special needs child and we need to make sure that they do not get disqualified from governmental assistance, you probably need a trust. You own a bunch of businesses and we need to make sure that we're properly addressing that. You probably need a trust. Not everyone needs a trust, despite what you might hear on commercials on late night, but you'll need to have sort of a candid discussion about your situation in order to determine whether your trust is an appropriate fit for you.
Absolutely. Yeah. So it really depends on the types of property you're leaving to your inheritors, the types of
Mhm.
assets.
Mhm.
So real property versus bank accounts would be
Yeah.
what would help you determine whether or not you needed certain types of.
More real property actually there's a weird statutory wrinkle in the state of North Carolina that addresses real property differently than a lot of other states that actually makes kind of transferring it easier sometimes at death than other assets. I'm talking more like you own a fractional interest in a large business, and we don't want to have to value that large business necessarily in the probate court
Okay.
as
Yeah.
part of that inventory. Yeah.
Gotcha. Perfect. Yeah. Well, we could talk for hours about this, of
Yes.
course.
Yes.
But we can't answer every question that everyone would have. Um, can you sort of give us what are some unknowns that we might want to be aware of that maybe a layperson early on would say, think about this as you're going through this, or keep this thing in mind, or this particular.
The big ones are there's not a huge rush. We needed to work on this, but there's not a huge rush. You don't need to pay all those bills tomorrow. You do need to keep track of them because we will need to address them, but you don't need to be paying them all right now. We need to figure out whether there's money with which to pay them. And a third unknown, I touched on this a little bit, but depending upon what the will says, or if there's no will, then this would definitely apply, is how real property, real estate, houses, land, how that is dealt with in the state of North Carolina. Title to real property transfers automatically to the beneficiaries of the will, unless you've directed that it be sold or it's going to your trust. And similarly, if you die without a will, then title transfers automatically to your heirs, effective as of date of death. What that means is it is not part of the estate, right? It already went to that end stop. It didn't stop in the middle. It didn't stop in the estate. It went straight to the end. That means the expenses of that house, utilities, homeowners insurance, property taxes, are not expenses that can be paid out of the estate account.
Mm.
And that is where people mess up a lot because it's mama's house and I got to pay that Duke bill or they're going to turn off the power. Now, there are situations where that's not true. If the will says explicitly that title is devised to the executor and so on and so forth, then we're not as worried about it. Think of your standard will. I give everything to my spouse, and if my spouse dies before me, then it goes in equal shares to my kids. My kids get the house and they start paying the Hendersonville water bill out of the estate. We've got some cleanup to do because that is not an asset of the estate. You and your siblings own it already. Okay. So just part of the planning and also making sure that you understand that when you go and meet with your estate planning attorney, your estate administration attorney, to understand who owns what and where can I pay this and where can't I pay this.
That's great. I would never have thought that.
Almost no one does. The number of realtors that I've educated on this is not insignificant.
Yeah. Yeah. Which only emphasizes the importance of having good counsel here.
Yeah.
Because not only are we trying to do this, with limited access to our full faculties
Yeah.
because of the grief, but it's complicated. So yeah, I think it's a smart thing to do. Just as it's as smart to do the advanced care directives that you want to do,
Hmm.
so that you can direct people how to treat you while you're living. You want to be sure to have these things in place so that your wishes continue after your death. And also, I think it's a smart thing for your heirs and beneficiaries because it's a gift you give them of peace of mind and not having to muddle through all these things in the grief. You allow them to grieve and
Yep.
then sort of do the work a little bit too with a little help.
And there is I have folks who come in and they have a lot of discomfort about talking about this, but I always try to tell them, can you live in this discomfort for a short period of time? Because then we don't really have to worry about it again for a couple of years just to make sure that the plan is the same. But yeah, you've created that peace of mind and this benefit for your kids or your heirs or your charities, whoever it may be. But also, you're just living in that discomfort for a short while. And I try to make it as painless as possible, but it's only so much I can do.
Absolutely. Well, Coral, thank you for your wisdom today. It's very helpful, I think, and just your commitment to Four Seasons is felt all over this organization. So thank you for what you do for us and for this community as well. Not only in your role there at Van Winkle, but as part of our family here at Four Seasons, we appreciate all you do and all the ways you contribute to the work that I do here, right? Because
Yeah.
as part of the foundation board, you make it possible for us to provide these services. Your advocacy and your commitment to this work is valuable. So we
Thank you,
appreciate
Daniel.
you so much.
I'm happy to be here and answer these general questions. Again, everyone's situation is different and it's
Absolutely.
very dependent, but at least we give you some guideposts. So
Well, good, good.
thanks,
That's
Dan.
all we need. A few guideposts here and there to help us along
That's
the
right.
way.
That's right.
I appreciate it.
Yes.
And all those watching, this will be posted on YouTube. You can post some comments or questions in the chat, but I don't know who's going to be able to answer those legally.
Contact your attorney.
So, but yes, always seek out your own legal advice in your community where you are. Find out who can help you there. If you like this format of questions about grief and connecting you with some other professionals, let us know if you like this, and we may do some more along the way. We just wanted to sort of answer this question first and just say, hey, this is hard, and there's help out there and we don't have to do this alone. So the most important thing I took away from today is it's okay to breathe
Yeah.
and it will get done if we just take our time and be smart. So
Slow and steady, baby.
slow and steady. That's right. Well, Coral,
Thank you,
I
Daniel.
appreciate you so much. Thank you. Thank you.
Yep.
And hopefully we'll see you all soon.
Sounds good. Take care.
All right. Bye-bye.